So sorry, I've been
All right.
live
Um,
for like 20 minutes, but I forgot to
so
push the button.
I'm not inclined
So
to
now we
do
have to
conditional
rewind
discharge.
because this
I don't know if that changes.
this is something else. I'm so sorry. I'm so sorry. I did the intro. I did everything. Sorry, I've been
All right.
live
Um,
for like 20 minutes, but I forgot to
so
push the button.
I'm not inclined
So
to
now we
do
have to rewind.
conditional.
Oh my goodness. I'm like, why aren't people commenting on this court case that is hilarious? You know, what is with what's happening with Judge McBurney's court? Why are we not talking about that? And everyone's like, oh, we just like hanging out. I'm like, oh, it's cool. I like hanging out too. I was talking to y'all. I gave away the internet. You guys missed. I went to the post office. I got 6 jars of pickles, spicy maple bourbon pickles. I gave one to the postmaster and told it with instructions on how to eat them, which is like 1 jar at a time. I did all this stuff. I played the music. Like I had, like, we did this part. Played the video. Got all the sound bites going. I'm sorry. I'm sorry. It was, I, I put in a lot more time in this channel than you guys see, apparently. So, all right, we've got court right here, right here. We have to go to court, and it's Miss McBurney's court, and it's
Gardner, we're going to do next. We got to do this. This will be
Gardner.
2 minutes, and then
I'm
we'll
sorry.
be ready for Gardner.
I'm sorry, Grandpa Brain. Worst start ever.
All right. We're going to get on the record in your case. It's 25 SC
After this one.
006794, State versus Dumbuya. You are charged, sir, with aggravated assault and possession of a firearm in connection with that aggravated assault.
That's pretty
Your lawyer,
serious.
Mr. Lane, is here. Ms. Smith is representing the state.
It's the one after
First,
this.
Mr. Lane, do you feel like you've got all the discovery in this case?
Yes, Your Honor.
You're good to go on that front.
Yes.
So that's why you said you're ready for trial. Ms. Smith, what is the state's offer?
That's the worst.
All right, Mr.
It's the
Dumbuya,
worst
do you
I've ever
understand that if you were to enter a plea today, the prosecutor would recommend that you serve 1 year in custody, followed by 9 years on probation?
Yes, sir.
Okay. Mr. Lane would be free to recommend a different sentence. He could recommend straight probation. If I were to sentence you to more than what Mr. Lane asked for today, you could withdraw your plea if you did not like the sentence you got. Do you understand that?
Yes, sir.
After today, you're still free to enter a plea. You can enter a plea in the middle of a trial. What changes is you don't get to withdraw it if you're unhappy with the sentence that you received. Do you understand that?
Yes, sir.
Okay. Last thing, the state's offer of 10 to serve 1, that's their offer today.
10 to
It may
serve
not be
1?
their offer tomorrow. It may get better for you as they learn more about the case. It may get less good for you because they say, well, fine, we're ready for trial. We've had to put in more work, spend time with the victim, and now it's 10 to serve 2 or something like that. You don't get to resurrect this offer if the state's not interested in it. Do you understand that?
Yes, sir.
Okay. Understanding all those things, Mr. Dumbuya, do you want to go forward with the plea today or have your case moved to the trial calendar?
Yeah, I want to move forward to the trial.
Okay, well,
That's what we'll do.
they put that on the calendar. I apologize. I was live streaming. I told you I'd come back at 2:15. I was like a minute late. I came back and I did the intro. I went live. I hit the live button. Everything was working great. I thought no one was really paying attention to me in chat, but chat was rolling. I'm highlighting. I'm making comments. I'm responding. I talked about what I did at the post office and the pickles, and I talked about the Karen Reed thing that's going on. Karen Reed, Ayden Kearney, with the McCabe's and how it's going to like currently on track for take 3 years, but the judge maybe we can speed this up and make it only take 2. That's going on up in Boston. I apologize. I blame YouTube. I blame YouTube because they make me every single time I make a new live stream turn on the setting that says that I have to manually select the go live button. So I have to go live twice. I have to once do it from my machine and once do it from YouTube. I always just have it run from my machine. When I go live here, it's live. And so I always change that setting. It won't let me save it that way. And I forgot to click that little button this time. And so There we go. Anyway, Kurt even saw this happen. That's terrible. I'm sorry, Kurt. Terrible example. Anyway, we're jumping back to court. The guy after this case, after they schedule this case, I don't know what's happening here. I don't know what's going on. But it gets a little spicy, it gets a little interesting. I was a little distracted. Blaming YouTube is a good play. Well, you know. All right, we'll let this case wrap up and let's see what this next little hearing is, because wow is all I can say. Wow.
June 16th.
Okay.
Yes, June 16th. We'll see you here.
All right.
Okay?
Here we go.
All right.
Buckle up. Let it begin. It was a long holiday, guys. I painted for hours, like 3 hours nonstop.
Now, Mr. Gardner, please.
Mr. Gardner, step right up. Oh, it's not him. It's after him. We're going to skip Mr. Gardner, okay?
Did you already do a waiver?
Yes, Your Honor.
Okay.
We're going to skip Mr. Gardner. We'll let him sit down. Nope, that was not right. It jumped.
Everyone know, if your mom moves and you move with her, you need to let everyone know that new address, okay?
Sure.
Or you could just move out of your mom's place.
Attorney Smith, anything else? All right. That's it.
Thank you.
Okay, I think it's this one. Buckle up.
You want to do Mr. Battle or?
Someone else.
Oh. Or Robert Henry?
Well, if you've got a final plea, we could knock a couple of those out. Not,
Oh, she lives in a time zone.
Okay.
To be able to get back today.
and what are we doing with Ms. Wycliffe? Hey, let's talk about that. That's quick. And then if you've got anyone who is simply doing a final plea, why don't we knock a couple of those out,
See
especially
this-
if they're in the gallery?
See this dude right here?
And then we can do
This guy?
Mr. Cohen, your client's plea. What did you,
That's the case.
Mr. Rhodes, figure out? You still need more time with Ms. Smith? Yes. You haven't been on bended knee long enough? You haven't been able to convince her yet of the wisdom of your situation? Okay. Oh, you haven't talked at all? Okay, she's been busy. You notice how many lawyers are here to help her today with all the other cases. So, okay.
IBM.
Let's turn then to that.
And Judge, I just want to let you know I'm logged on at this time.
All right, thank you, Mr. Fortis.
Okay.
IBM used to require their employees to come to work wearing a shirt and tie. Long after other employees abandoned
Ms.
the dress code. by the way.
Wycliffe, can you turn there we go, add you to the screen. There you are. Whoop, you got really dark. You need to be less dark than that. There we go. It's still pretty dark. You have any light bulbs in the apartment?
Yeah, I just hold on.
These power bills don't pay themselves, Judge.
All right. Great. Yeah, you are in a different time zone.
Mood
Okay.
lighting. There we go.
So I don't think we even need to be on the record if we're just doing diversion. Why don't you tell me, Ms. Wood, what's happening? I'll make sure Ms. Wycliffe understands it and that Ms. Smith says, yes, that's actually happening.
Sure, Judge. So Miss Williams and I started
This is
talking
not it
about
either.
diversion.
I keep missing it. It's the dude in the tie that I pointed out. It's not her either. Nope. Ma'am, appreciate you. Oh, here he is. There he is. Okay.
Okay.
All right. Should we do
Yes.
the Metreon plea now?
Yes. Mr. Metreon, whatever he is back there. Gives
And
the
then
big
we'll
nod of
do
approval.
Mr. Fortis's client's revocation.
Step right up, sir. Who does he remind you of, by the way? Who does he look like?
Beat the meter, but I think I'll gamble.
Ms. Smith's pretty efficient. That will get through it.
Shade will be cast during this. We're gonna have some. Yes, Rudy. That's him. It's Rudy. He gives a couple backhanded compliments here that I think you guys might enjoy. It's Sam from Lord of the Rings.
You ready? Okay. All right. Let's get on the record.
Sound
Position
like it.
11 on our final plea calendar. State versus Metreon. 25 SC 007846. Good afternoon, sir.
Good afternoon, Your Honor.
Mr. Metreon is here with his lawyer, Mr. Cohen. Ms. Smith is representing the state. Mr. Metreon, in a moment, Ms. Smith is going to put you under oath. Once you are under oath, you need to answer her questions and mine truthfully and completely. You also need to let your lawyer or me or both of us know if at any point you have questions. Things
Yes,
aren't
sir.
making sense, or Mr. Cohen said it's going to go this way and it goes that way. Anything like, wait, what? You need to stop us and have someone explain it to you, okay?
Understood, Your Honor.
All right. Ms. Smith?
Yes, Judge, thank you. Mr.
Metreon.
Trion,
Yes, ma'am.
please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Matthew Ryan Metreon.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
Yeah, I'm prescribed to Lexapro, Buse bars, anti-anxiety, and trazodone for sleep. But I did not take the medication this morning because I haven't had a chance to eat yet.
Does the fact that you have not taken the medicine make it hard for you to focus on what's going on?
No, absolutely not. It's an antidepressant, anti-anxiety, and then a sleeping pill at night. So
Okay, but sometimes I've had folks in here who didn't take their anti-anxiety medication,
Yeah.
and they're very anxious because court's not always a warm, fuzzy space. You're doing okay.
yes, sir.
Okay. Maybe you don't need the medicine anymore.
Hopefully.
How old are you and how far have you gone in school?
I am 36 and I have a bachelor's degree in business marketing from the University of Alabama.
The University of
Ooh,
Alabama.
so you're recommending jail, I assume.
Come on now.
I'll get the University of Alabama, even though my youngest daughter graduated from there.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied that your client has an understanding of this proceeding?
Absolutely.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Absolutely. Indeed.
And indeed.
Mr. Metreon.
Metreon, yes, ma'am.
Metreon,
Yeah.
do you remember being arrested on these charges?
I was completely blacked out.
So that's a no. I'm sorry.
The state is unaware of any outstanding warrants related to these charges. Are you or your client aware of any outstanding warrants related to these charges?
I am not. I believe all of the charges have been, he was arrested for and is now being prosecuted for.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I do. And I am.
Mr. Metrion,
Yes, ma'am.
has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
Seems
No,
like
ma'am.
it's going just fine, right?
As to indictment number 25 SC 007846, how do you plead to counts 1, 2, and 3, terroristic threats and acts?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction, but if you believe that there has been some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
I do now.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, if this case were to proceed to trial, the facts would show that on August 20th, 2025, officers responded to the 6 Concourse Parkway address that's in Sandy Springs, where the company NX Direct was located. When the officers got there, they spoke with a Venice Asino. That's
NX Direct.
VINICIUS. Last name is ASCENCAO. When they got there, the victim told the officers that they received some text messages via LinkedIn from an employee that had
LinkedIn.
started at the business around 6 days ago. The victim was able to identify that person as being the defendant in this case. The victim in this case showed the officers text messages that was sent from the defendant to the victim in this case. Those text messages, there were a lot of them, but some of them were telling the victim that he would take everyone out, the victim and everyone at the business, that they should kiss their families tonight because tomorrow they will all be dead. And other statements like, go ahead and let everyone know that 400 near Sandy Springs will be shut down. The business is near Sandy Springs 400.
Excuse
The
me?
victim in this case told the officers that the defendant not only threatened him, but also threatened his business partner in this case and other employees that worked at the business. I was able to talk with the victim, Mr. Vinny, in this case, who told me that he was okay with the state's offer of 5 years probation. His main concern is that he just wanted to make sure that the defendant would stay away and that he would not have access to the business anymore. Also, I was able to speak with the secondary victim in this case, who told me that he still looks over his shoulders to this day. He does not want the victim to be around, and he didn't have that many conversations with the victim, so he was kind of shocked when he saw his name directly in some of those threats that the defendant sent to the victim via LinkedIn. All of this occurred, well, the messages were sent to the victim that was located in Fulton County. Therefore, this alleged offense
find
here
out. We'll find out.
was committed in Fulton County. Regarding the negotiated plea between the state and defense. We've agreed to 5 years probation. That's for counts 1, 2, and 3 for them to run concurrent. For the special conditions of probation, the state is asking for the defendant to complete an anger management course,
Yeah.
to have no contact with either of the victims in this case. I believe count 3 lists the employees of the direct company as victims. The state will also be asking for anyone that's an employee of the direct company, for the defendant to have no contact with them, and also for the defendant to stay away from the incident location, is what we're calling the location of the NX direct company. It's my understanding that the defendant was hired there 6 days previously before these threats went out on LinkedIn. And lastly, Your Honor, the state is asking for the defendant to complete a mental health evaluation with treatment if necessary. That's all from the state.
Thank you.
Whoo. Pre-trial.
Ms. Smith-Mann, any criminal history information from Mr. Metreon?
Your Honor, this is a multi-state offender with 4 cycles from Georgia, 1 Alabama, 2 from Tennessee. I'm not sure if this is the same case. With last arrest 9/3/25, Fulton County, 2 counts of terroristic threats, 2 counts of simple assault, open 25 PI 007116. There was a first offender in Cobb County in 2019.
Yeah, that didn't work.
Of terroristic threats. However, it was discharged in 6/21. Nothing further, Your Honor.
Thank you.
Wow.
Mr. Cohen.
Your Honor, if it please the court, what the court has heard is accurate. What the court has heard is a boy in a man's body. He had been smoking marijuana, weed, evil weed, call it what you want to call
Evil
it.
weed, right?
He had
Devil's
been
lettuce.
doing far more alcohol than any human being should do. Since the time that he's been arrested, he had an ankle monitor for a while, which was removed. He has not had a drink. He is continuing to get counseling, and I provided that to Ms. Smith. He will continue to get counseling. And by the way, this is under conditional discharge, and please the court, since he has used his first offender.
Oh, he used that one up for sure.
I have made clear to him on numerous occasions, and by the way, that this is it. There is no more. This is the precipice, 1 inch the other way, and he's got a record that's going to last the rest of his life. I think he's sort of like NATO, no action, talk only, but this was horrible talk. This was something that one should never do.
NATO?
Be they under the influence or not. It's unacceptable. And I've counseled with him numerous times, and I've spoken with his mom on numerous occasions.
Oh, that's
I know
serious.
his dad passed away, and that was difficult. But all of us go through something that's bad. Some of us more, some of us less. This is it, Your Honor. And I'd ask the court to follow the recommendation.
Mr. Metreon, tell me, Mr. Cohen said you're receiving, is it drug treatment or
gets
what?
better.
What is it?
No, Your
Addiction
Honor.
counseling?
Just straight up regular counseling. I've been going since the arrest date, and just kind of working through my anger issues, mainly due to like how much the country's changed in the last 5 years. Can't really wrap my head around it.
Pickles.
And they, the reason this happens is because they lied about the starting salary. And I figured that out when I got my first paycheck. So I will be reporting them to the Better Business Bureau.
No, you will not.
Okay.
So who said that? His lawyer?
I have in the system that you got arrested twice in connection.
It was the same night, but then the other two, like when that night I got arrested, they took me to the hospital, and then I went to Peachford Mental Hospital for 5 days. Mm-hmm. While I was in there, my family spoke with the Sandy Springs Police Department multiple times. They said, "Oh yeah, there's no charges. He's going to the mental health facility." As soon as I get out, a day later, right when college football kickoff, the first one happens, boom, they surround the house, arrest me. I bailed myself out. It was over the weekend, so I had to wait 3 days. I get out, a day later, they arrest me again for the same night, surround the house.
Okay.
Basically, Your Honor, in my view, he brought it upon himself.
Right. No, I'm not having a big pity party for him right now. I just was curious why there were two arrests. It looked like it was for the same conduct.
Hashtag no pity party.
So what did NX Direct do? Like if
So
you
they lied about
no, I didn't ask that well. I don't want to hear that part. What line of work are they in, and what would you have done for them?
So it was a sales position,
Okay.
but I was not aware it was harassing people in Walmart's to subscribe to AT&T.
Walmart.
Huh.
So it's bottom feeder sales, but they didn't explain that. And then when I started working, I was in a desperate situation, so I stuck with it. And yeah, I can't stand those types of companies. They trick people.
Just back up a little bit. I won't play the Walmart soundbite over this.
My family spoke with the Sandy Springs Police Department multiple times. They said, "Oh yeah, there's no charges. He's going to the mental health facility." As soon as I get out, a day later, right when college football kickoff, the first one happens, boom, they surround the house, arrest me. I bailed myself out. It was over the weekend, so I had to wait 3 days. I get out, a day later, they arrest me again for the same night, surround the house.
Okay.
Basically, Your Honor, in my view, he brought it upon himself.
Right. No, I'm not having a big pity party for him right now. I just was curious why there were two arrests. It looked like it was for the same conduct.
He really wants
So what did NX Direct do? Like if you
they lied about
no, I didn't ask that well. I don't want to hear that part. What line of work are they in, and what would you have done for them?
So it was a sales position, but I was not aware it was harassing people in Walmart's to subscribe to AT&T.
Huh.
So it's bottom feeder sales, but they didn't explain that. And then when I started working, I was in a desperate situation, so I stuck with it.
6 days.
Yeah, I can't stand those types of companies. They trick people. I was a corporate recruiter for 10 years dealing with six-figure IT executives. So that's I felt some type of way that it was beneath me and that I was not being paid what I was told I was being paid. And I did the wrong thing. I had a momentary lapse of judgment. I drank. I hadn't had a drink in like 6 months before that.
Right.
And, when that anger builds, I just go straight to that booze. So not anymore. I haven't had a drop since that night.
So you get angry again. Talk to me about the Cobb County case. So in June of 21, 5 years ago, you got a first offender for terroristic threats and acts. What was that one about?
Yes. So when they were arresting me for disorderly conduct, I was blacked out drunk, and I guess I fought back, and I definitely, I grew up wrestling, doing jiu-jitsu, playing football. So, I definitely gave him a hard time. And then I guess I threatened one of them. I have no recollection of that night, just like this.
So it involved law enforcement as opposed to an employer.
Correct, as they were dragging me down the driveway.
Okay. All right.
I remember that part.
So I'm not inclined to do conditional discharge. I don't know if that changes what you all are going to do. But given what the first offender was for and sort of how I've heard things today, it's a final plea. So Mr. Metreon can always back out. But I just want to let you know, I am fine with the other pieces of the case, the 5 years probation. I was even going to set a behavioral incentive date, anger management, clearly no contact with anyone or anything to do with NX Direct.
Or Walmart.
But I don't see this as the right case for a conditional discharge. Not because it's not drug charges. I get the connection to your addiction and whatnot, but because I see it as a second offender. I see this as another instance of what happens when things don't go well for you. And you had a first offender for that Cobb situation. So that's where I'm with this. All the other pieces I'm all right with, but I don't intend to have it be a conditional discharge sentence. I'm happy to hear from you, Mr. Cohen, because you moved into the speaking position. But I also want to give you and your client a chance to talk because Mr. Metreon may say, I got to go to trial. And I respect that, and we'll do that. But that's where I am.
Your Honor, for please the court from the defense side, it is not a triable case. It is not a winnable case. and he understands all that he did that was wrong, I'd ask the court to reconsider, because I hate to see someone who has 36 years behind him and a lot more in front of him not have the ability and the opportunity to continue on his life in a way that is appropriate for those people who have graduated the University of Alabama, if you will.
Or any other school. I get that. It's a complicated situation for him. I work with young men and women all the time who catch one felony or six, and they work their way just okay through life as well. I think it is an appropriate consequence for this second incident. It says to me, and I think to others, that whatever happened the first time, I don't know that it's the first time, but the one for which first offender was granted didn't yield the kind of changes that I'm sure, Mr. Metreon, you wanted to make in your life, but they didn't go all the way through. And there's not a third offender. So I think that the appropriate outcome is for there to be a longer term consequence as a result of what happened here.
You know, I only say this was by LinkedIn. This wasn't a phone call. It wasn't even direct text. And that doesn't in any way absolve him of any of what he did.
I heard the facts. I understand. If it's not going to be a tribal case, then if it's not a tribal case, it doesn't sound like it is. It sounds like we're going forward. It's just not exactly what you were hoping for. So, Mr. Metreon, I'm sentencing you as to each of the 3 counts to 5 years probation. Special condition of probation number 1, no contact, direct or indirect, with either of the gentlemen whose names we heard. It'll be written on your sheet, your final disposition, but also anyone who is associated with NX Direct. That's probably the easiest condition you've got, because you seem pretty fed up with them and the fact that they weren't straight with you about what line of work you'd be in or what you'd earn. Number 2,
report them.
You should have a mental health evaluation and follow any treatment. I think you've got your arms around that already.
Yes, sir.
And that's going to be one where you just engage with your probation officer, and it may well be that they say, heck, you're receiving counseling, and so let's not go there. But if, especially if you have the kind of prescriptions you said that you've got, it may be that that's unnecessary. I just want to make sure.
It's absolutely necessary.
Okay, that we're not leaving a piece of that unaddressed. You'll need to take an anger management course. Probation can help line that up. It'll also be a condition of your probation that you continue your counseling until a counselor says, I don't need it anymore.
He says I'm good, but if you want me to keep going, I'll keep paying.
No, if your counselor says the years that Mr. Metreon has put into working through his issues, because I thought you were still going. That's what I heard Mr. Cohen say.
Yes, I was, but after the court date, I figured that would cease.
If the letter from your counselor is you're in a good space, then it can cease.
Okay.
If the counselor says, 6 more months, I defer to that subject matter expert. I don't want to impose it if he or she is saying it's not necessary. So that'll be a call to be made by the counselor or therapist, whoever you're seeing. And that is it. I will set a behavioral incentive date of May 27th. 2029, that's 3 years from now. If you have done all the things you needed to do on probation and there have been no hiccups, no arrests, nothing like that, they can close everything out 2 years early.
2 years, okay.
Yeah.
Yes, sir.
And your counts all run concurrently with each other. What county do you live in?
Fulton County, Sandy Springs.
All right. Ms. Simpson, who is with probation, but who will not be your probation officer, is going to give you reporting instructions. She'll meet with you right outside the courtroom. Don't miss your first date. That's the most important one.
Yeah.
You'll need to come to the office, introduce yourself, give them your actually, you'll probably give your contact information to Ms. Simpson. But once you make that connect, then your officer may be fine with phone calls or dropping by every once in a while. But that initial report is the important one.
Yes, sir.
All right. Ms. Smith, anything else from the state?
No.
Mr. Cohen?
Only have a nice afternoon.
Hey, thanks. I appreciate it. Make sure you.
What's going to happen?
So just to be clear, so am I getting charged with a felony?
Yes.
Yeah.
Yes.
Okay.
All right.
Yeah.
Thanks, everyone.
if you filled it out.
I think the judge made a good call on that.
Oh, hold on one second. I need to get a couple more things on the record.
Come on back.
Because I got distracted. I focused on something different. And then you can get with Ms. Simpson.
Careful, 'cause
first,
you're
Mr.
gonna angry
Metrion. Your signature is on. You and Mr. Cohen filled out our plea of guilty form.
Yes, sir.
And you initialed next to lots of things. You had all the time you needed to talk with Mr. Cohen about the form.
Yes, sir.
And then on page 4, you signed it.
Yes.
All right, Mr. Cohen, you signed it as well? Your indictment, Mr. Metrion, can we electronically sign your name to it indicating your plea to the 3 counts?
Yes, Your Honor.
Mr. Cohen, can we sign for you?
Absolutely.
And Ms. Smith, can we sign for you? All right, based on all that, I find there is a factual basis for your plea, and that your plea is knowing, meaning you've understood what we talked about, and voluntary, meaning no one's forcing you to enter this plea, but you've decided after consulting with counsel, friends, family, whomever, that it's in your best interest to go forward with the plea. Now you can meet with Ms. Simpson.
Awesome. Thank you, Your Honor.
You're welcome.
You guys have a nice afternoon.
You too.
I told you that one went off the rails. The bottom feeder sales, harassing people at Walmart to sign up to AT&T. Let's jump over.
You all have something you want to do? We'll take a break in a little bit. I know Mr. Rhodes needs to speak with Ms. Smith. Ms. Smith probably could just use a break period, but
we'll jump over to Kansas.
Do we have any other final plea things we could knock? Oh, we're going
to jump to Kansas, Judge. That's what we're going to do.
What is the name of? Oh, Robert Scott Williams. Okay. We are on the record in GW 2024 TR 549, State of Kansas versus Robert Scott Williams, County Attorney Jill Gillette for the state. Mr. Williams appears in person, in custody, and pro se.
Ooh, pro se.
Mr. Williams, you
I'm in your spot, sir. Sorry.
have had a number of hearings on these matters. Your most recent was scheduled for February 13th, 2026, a warrant to show cause why your probation should not be revoked. You were in person at that time and with Attorney Blake Cooper.
I think Jimmy's driving.
At which time you knowingly and voluntarily waived your right to hearing and stipulated to violating probation. You were found in violation, revoked, sanctioned to serve time, and to be reinstated on supervision or supervised probation for 12 months from that date. Now, Ms. Gillette, why are we back here today?
Judge, there's a new motion to revoke probation, and there's a warrant to show cause.
That's what I was afraid you'd say. All right, there was a motion to revoke your probation filed again May 20th to 26th, just 6 days ago. And in that motion, the state alleges you violated your probation by failing to pay your costs and fines as directed, with no payment having been made to date of filing the motion. That you failed to report to your probation officer as required on April 27th to 26th, that you failed to complete the special conditions of probation for an alcohol and drug counseling treatment evaluation and a DUI victim panel. It's also alleged that while you were placed on reporting probation for 12 months on February 14th of 2025, a probation revocation was held February 13th of 2026, and you were reinstated. You were approved for courtesy supervision by Lyon County Court Services, April 29th of 26. But per affidavit submitted by their court service officer, you failed to report on April 27, 26, and on April 29 of 26, you completed a drug and alcohol test via oral fluid collection on 4/29/26 at your initial appointment, and on May 5th of 26, the test came back positive for methamphetamine, amphetamine, cannabinoids, THC, and opiates.
Ooh.
And on May 5th of 26, you requested a confirmation test from Cordant Health Solutions to see the breakdown. On May 7th of 2026, the confirmation test showed the initial test has confirmed positive for amphetamines at 11.84 nanograms per milliliter, methamphetamine 140.56 nanograms per milliliter, and THC 473.57 nanograms per milliliter. They also say that to date, you have failed to complete treatment as recommended and failed to complete the DUI victim panel as required. You do have the right to an attorney to represent you in this motion to revoke probation. You also have the right to contest the allegations and have a hearing on that. Do you intend to hire an attorney or apply for court appointed, Mr. Williams?
Apply for a court appointed.
Where do you work?
I'm at Taco Bell and Emporia.
What do you make per month?
Not enough.
About 1,600, 17.
Married or single?
I'm sorry?
Are you married?
No, I'm separated.
All right. Do you pay rent or a mortgage payment?
Yes, I do.
How much per month?
$350.
Do you pay utilities?
Yes.
How much
I
per
pay
month?
150.
You own an automobile?
Phone bill, internet. That's about it. But I pay 100 in internet and 20 on my phone.
Do you have an automobile?
No, I don't.
You pay any kind of insurance?
No, I don't.
All right. I'm going to find that you qualify for court-appointed attorney. It looks like you've had Marcus Blake Cooper in the past, and I will reappoint him. And Missy, when will we have his show cause hearing?
These are traffic cases, so we'll set it July 17th at 11.
You must be back here in person at the courthouse, July 17th at 11 a.m.
Why
That's
is he
in
in
person
custody
at the
for
courthouse.
traffic?
You must call your attorney, Mr. Cooper, between now and then and be ready to go.
And he doesn't have a car.
Miss Gillette, anything else we need to cover?
I don't believe so, Your Honor. Thank you.
You're welcome. Anything further, Mr. Williams?
Is there any way I can get a OR bond so I could go ahead and go to Clearwater and get my stuff taken care of up there? So then you guys could release me so I can, because I have a hold from Clearwater for, that's traffic, but it's an old case.
No, I'm going to leave the bond where it is. Thank you, sir. You may go.
Thank you.
Oh, wait, Mr. Williams, you have another case here, too.
Uh-oh.
We're also here on the record in GW 2024 TR 579, State of Kansas versus Robert Scott Williams. County Attorney Jill Gillette for the state. Defendant Robert Scott Williams in person, in custody, and pro se. In this matter, sir, you're also looking at this is a second violation of probation and alleged as well, Ms. Gillette.
Yes, Your Honor.
All right. Generally, the allegations are pretty much the same. Once in a while, one will have a little more conditions. They're alleging you failed to pay the money due, failed to report, failed to complete alcohol and drug counseling treatment evaluation in the DUI victim panel. Court revoked and reinstated your probation, supervision to Lyon County. Came back positive for the drug. So it looks like it's pretty much similar. So we'll set that, Ms. Gillette, the same day, July 17th.
Yes, Your Honor.
At 11 a.m. And I'll appoint Blake Cooper on this one as well. And your bond will remain. So you may go, sir. On both of these cases, remanded back to the sheriff. You're welcome, sir. You have someone else right there, Deputy?
He's out of the room. 1 second.
Okay, no, that's fine.
She had to go get a female. We might take up Mr. McClendon.
All right, Mr. McClendon, who do you have?
Jimmy Barnes, Your Honor.
Jimmy.
And you may have to refresh your screen.
Me?
He should be at the end of the docket. I didn't know for sure if they were going to show up today or not.
Jimmy Barnes, we keep hearing about because he failed to come to court. Let's see. Okay, found the refresh, hit the refresh. Would he show up at the bottom, maybe?
Yeah, he'd be number 20.
Okay. All right. We are on the record in GW 2025 CR 114, State of Kansas versus Jimmy Allen Barnes, County Attorney Jill Gillette for the state, Attorney William McClendon for the defendant. Where is the defendant, Jimmy Allen Barnes?
He should. I see him on my screen, Your Honor. Mr. Barnes, if you'll speak for the judge.
Okay, I see one with tattoo and beards. Looks like tattoo and beards anyway. All right, so the defendant appears in person with Mr. McClendon, County Attorney Jill Gillette for the state. We're here on criminal possession of a... I thought he had a traffic matter he wanted to be heard on, Mr. McClendon. He failed to appear October 31st, 2025, and a bunch of other days for preliminary hearing because he was in federal prison and a warrant was issued. So what are you wanting to do with him today, Mr. McClendon? He was put on here at your request.
Well, yes, Judge. So when Mr. Barnes was released from federal prison, he was not picked up by the Greenwood County Sheriff's Office. Therefore, he's taken the responsibility and coming here today to try to, get this matter resolved. I've talked to his bondsman. His bondsman is willing to take him back on his bond. I just asked his bond be continued, and we set a date for preliminary hearing. His bondsman is Jerry Collins. He's willing to continue him on that bond. Mr. Bonds is showing a lot of responsibility here to be here today, and honestly, he's been pestering me trying to get a court date. So I'd ask that he'd be able to be continued on that bond.
Ms. Gillette, what has the state to say?
I know he went to federal.
Miss Gillette is struggling.
I'm sorry, Miss Gillette, you're coming across garbled. I'm not making out what
You sounded like
back here,
right here when Mr. Aguirre when he reboots.
I don't know why he has not been brought back here on the no bond hold when he was released from prison.
My client's statements in regards to that would be federal prison gave Greenwood County the notice, and they held him for 30 days, and after that 30 days he was released. So here we are, Judge. Picked up or not, it would be unfair to him, especially him coming here essentially turning himself in to just not reinstate him on the bond, Judge.
Well, unfair to him. Just a minute. He got himself put in federal custody and couldn't be here. So it's really appropriate that he have a warrant. The problem with this case, as you know, Mr. McClendon, is that warrant status is really unclear. We've had bench warrant bond forfeitures. We've had them set aside. We've had them reissued. It's just been a nightmare. So in that sense, if he's tried to turn himself in, as I think he has, or as he alleges he has, to get on the docket today, that would be unfair to him, because if he's going to the sheriff's office saying, take me, here I am, and our warrant's not clear, then that's no one's fault. So, all right, let's assume we get that warrant issue resolved today. What do you want to do with his criminal possession of a weapon by a convicted felon charge? You want to set that for trial? Do you want to enter a plea?
Judge, it would be a felony, so I think he's entitled to a
Prelim-
preliminary hearing.
You're right, and that's what he's filled up here for a couple of those. So we will set that, Missy, for preliminary hearing when? Give Miss Gillette time to get her witnesses again.
I have July 10th at 3:30 available.
Does July 10th at 3:30 work for council?
Me, Judge.
Miss Gillette, if you want to check that date of July 10 at 3:30, and you are muted.
I was just looking to make sure one of the officers that's out wasn't on this case, and he's not. July
Okay.
10th at 3:30 is fine.
All right, Mr. Barnes, I'm going to set your preliminary hearing one more time, and you better be here this time. Don't get arrested by federal marshals. Don't get put in federal custody, state custody,
Avoid the
city
feds.
custody. Be here. And because of the bizarre position of the warrant we've had here in, I'll listen to both parties if you want to be heard on that bond. But if Mr. Collins bail bonds wants to pick up that $5,000 bond that he posted June 23rd or 25, I would reinstate that. But I'd be, if there's objection to that, I would reconsider. Hearing no one, Mr. Barnes, I guess it's your lucky day. I'm going to reinstate that bond if Collins bail bond's willing to take the risk again. But you have to be back here July 10th at 3:30 for preliminary hearing.
I was going to say, Judge, the bondsman would have to be agreeing to be back on the bonds. I don't think we can make him be back on the bond.
That's true. So you better get yourself turned in and call Mr. Collins and make sure he's willing to take you back.
Judge, this is the one where the sheriff's office said they don't have a warrant.
All right.
You can't turn yourself
Mr. Barnes, your hand is up. Yes, sir. Unmute. Mr. Barnes, unmute. I can't hear a word you're saying. Look on your telephone. Click on that little red icon that looks like a microphone with a line through it. This case, and you are testing my patience. What's it say his first name is?
Jimmy.
Well, I don't know what his question is. He can't seem to figure out how to work his phone. If you're talking on a telephone, run your finger down the side or the bottom of your phone. A little red icon that looks kind of like a microphone with a line through it should pop up, and then click on that. And you should be, there you go.
Can you hear me now?
I can. What do you want to tell me, Mr. Barnes?
Okay. I did speak with Jerry Collins, my bondsman, and he said when I went to court today that for me to tell the judge that he was willing to put me on the bond and that he was willing to be my bondsman, and he didn't have a problem with that, and to let you know.
Well, he better put it in writing, because if you don't come again, he's going to lose every time he's put on you.
I was going to say, I can't take your word for what he says. I have to hear from him.
Okay, so do you want me to call him and have him call you, or?
Not me. I would say call him, and the two of you meet at the sheriff's office and do what you need to do to sign a new bond. Even though they may not have a warrant, I need to have some commitment that you're going to be here, or we need to get this money taken from that bondsman soon.
Well, I think the detainer letter to come and get him did not go to the sheriff. It went. I have one for the court clerk that they sent a letter to the court clerk and not to the sheriff's office. And we talked with the sheriff's office dispatch, and they said that they would keep it on active November 19th of 25. So it's still supposed to be active. And when we spoke with dispatch, it was supposed to still be active.
Well, and our computer system still shows it's active.
Mm-hmm.
So I don't know why the sheriff's office was saying they don't have an active bond on it, but whatever we need to do to get this cleared up. Mr. Barnes, you're raising your hand again?
Yeah, I talked to the clerk of the courts there, Miss Ashley, and she said there was no warrant for my arrest, but I can get a hold of my bondsman and see if he's available to come up there today. I'm not going to skip out on court date. I will be there because I'm on federal parole, and I have
the court clerk cannot disclose warrants. She's not the one who takes care of warrants. That's the sheriff.
Okay.
Well,
Ashley's
there's
in
a
trouble.
statute that says they're not to give that information.
Well, okay, I'm sorry. She did. I'm just
I'm
telling you,
sorry
I
she
didn't,
did.
I didn't
And
know.
I'm telling you, sir, that you
Yes,
do
ma'am.
have a warrant, and I'm telling you because I want you to turn yourself in on it, you and your bondsman.
Okay.
That's the reason I'm telling you. You need to get that cleared up.
Okay, ma'am.
And you
I
said you
will,
want.
I'll contact him as soon as we hang up and see what we can do.
All right, but if you aren't here on that date given, in fact, I'm going to order that you wear an electronic monitoring device as a condition of your bond. Deputy, he needs EMD, just so I know where he is, so he doesn't, when he does disappear again, we'll find him a little easier. All right, anything further? We'll be in recess at this time
Yeah.
on the Williams case. Yes, Mr. McClendon?
Just want to clarify, are you ordering my client to be in person on the 10th or
Yes.
no? Yes,
Yes.
okay.
He needs to be in person. I think I said that. If I didn't, Mr. Barnes, be at the courthouse in person, not on Zoom next time.
Yes, ma'am.
All right. Thank you, sir. You're excused from today's hearing.
Okay.
Now we go back to Greenwood County Jail.
Can I speak with my attorney? How do I do that?
Just
Well,
give me a call.
Okay. Thank you, Your Honor.
you're welcome. This is who you want to take it next. You have someone else you want to take up next. Is Blake Cooper waiting on us?
No, them are just all warrant to show cause. I think Miss Thomas is in jail. She would probably be the next one.
Okay, we'll take her next time.
Comes Miss
We are
Thomas.
on the record in GW 2025 CR 42, State of Kansas versus Sierra Lynn Thomas, County Attorney Jill Gillette for the state, Defendant Thomas in person and pro se. We had a bond, the last hearing was a bond forfeiture. The state withdrew the bond forfeiture motion, but the bench warrant remained active. Apparently she's been picked up on that bench warrant, which was issued when she failed to appear January 20th of 26 and was ordered a no bond hold. Miss Thomas, back in October of 2025, you were here with Attorney Richard Paw. You told us you had a diversion application. I'm sorry, the county attorney said they had sent a diversion application to you, but you hadn't sent it back, and you said that was because you didn't have any money available. You asked that I continue this case so you could get money, and the state did not object. So from October of 2025 to January 20th of 26, this case was continued at your request. And then when that January 26th date came, you failed to appear. So how do you want to proceed today?
Your Honor, I was picked up, or I have been incarcerated from January 6th through May 18th in Butler County Jail. I got out. They let me out of jail on the 18th. On the 21st, I went and checked in with my corrections officer, Ken Clausing. He let me know that I had a warrant. There was a misunderstanding. I thought, so I got sentenced to corrections on my case in Butler. They did a global resolution. I was not made aware that that doesn't cover all jurisdictions. It was just that county. I wasn't too sure because when they let me out of jail with no holds, they said I had no holds. I thought I had a clean slate. That's why I went and checked in with Ken. I was going to put myself into inpatient treatment that day. I was going to talk to him about all that to get myself set up so I'm not in a situation to be put back in jail again. But he told me that I had a warrant. So I am here, and all I ask is that maybe we could think about getting a bond, putting a bond for that case.
What case are you talking about getting a bond for?
If I'm correct, I think I have a no bond hold for
CR 42.
CR 42. I believe.
You know that's the case you're appearing before me on right now?
Yes, ma'am. Yes, ma'am.
You're charged with transmitting falsely information by telecommunications, reporting that emergency service assistance was needed. So that is an A misdemeanor. That was allegedly occurred March 28th of the year 2025. Your first appearance was May 26th. No, that's not the first appearance. That's anyway. You've had a lot of hearings. You kept saying you were doing diversion. You had an attorney representing you. Did you ever complete the diversion process?
No, Your Honor. I ended up getting locked up.
Ms. Gillette, how does the state want to proceed at this time?
You know, she needs to be set for revocation on the 24 CR 118, and that is in front of Judge Ricky. And then her other case, the 25 CR 42, I believe it just needs set for a control. I was looking, she last had Mr. Ambrose on the felony case, and she had Paul under the contract on the misdemeanor case.
So the one in front of Judge Ricky, is that a show cause, a warrant to show cause on her felony?
We're about to jump.
And then the one that I have here is a diversion revocation on a misdemeanor, is that right?
Yes.
Okay. So set the motion for diversion revocation on my docket. Missy, what do you have for her? Missy, did I lose you there?
Paging Missy.
No, I'm here. I don't think it's a motion for diversion revocation. It's just a hearing because she never did do her diversion paperwork.
Oh, she never got it in. She never got the paperwork in.
So
Okay,
that one's
I need to-
6/23 at 3:30, and I wasn't aware of the other one. No one mentioned that case to me, so I didn't have it on the docket, and I don't have a date
All
for
right,
Judge
so,
Ricky.
well, when she gets served with that, she can reappear. All right, so on 25 CR 42, the only one you're here on today, I'm going to set that back. That's a misdemeanor control missing.
Yes.
You must be back here that date, June 23rd at 3:30.
We're going to jump to Simpson. He had something spicy happening here.
Looks like you posted a $2,500 bond with Hot Rod on April 11th of 25.
Hot Rod Bond Company.
But has that been revoked, perhaps, as long as that's been?
Yes, she failed to appear.
Yeah, she's
Well,
a runner.
March 30th to 26th, state withdrew bond forfeiture motion. So
All
it
right.
says bench warrant remains active. She'll still
We're gonna
have to
jump.
post a new
We're gonna
bond.
jump. Here we go. This is a recommendation from Josh, who bailed on us.
They should have also said, although she's left for purposes of the record, I checked with community corrections because, quite frankly, like I said, I don't believe anything that she says. And I checked with community corrections, just make sure there weren't any interim violations of her alcohol. They reported to me that at this point there are none.
Okay, good info, Judge. Thank you.
Court does call the case, People versus Corey Folk.
Corey, step up.
And Lord Yagi, Assistant Public Defender with and on behalf of Corey Folk, who's approaching. Could you say your name for the clerk? Corey Folk.
Starting time set for preliminary examination. Are we ready to proceed?
People are ready to proceed.
No, Your Honor. If I may be heard, I know we had a bench conference about this case. Just to put on the record, I indicated that I felt, given the voluminous discovery in this case, I felt unprepared to proceed to exam today, especially given the nature of the charge and the people's representations and just how much discovery there is and how complicated this case is. And as I was sorting through the discovery earlier today, I realized that the witness intent call today was interviewed by police and it was recorded. And that was not disclosed to either side. My position is, Your Honor, that it is a discovery violation under 6.201, recorded statement pertaining to a lay witness, that is mandatory disclosure. And I looked up some case law where there's support for some sort of remedy, which includes either precluding the witness from testifying, or giving the defense an opportunity to review the discovery beforehand. So I would either ask that the court prohibit the witness from testifying because we don't have the recorded interview with police. And I should note also the police actually implicate the witness, I think, based on the notes that are there in terms of what actions the witness may or may not have taken, their motive, their credibility as it relates to the actual allegation, which is of the utmost importance in this type of case, the credibility and the reason why they're testifying, if they're subject to any criminal charges themselves based on their actions or inactions. And my position is either
making your argument that it's violation. Are you saying that the people knew?
Well, Your Honor, they should have known. And if they,
well, yeah, you're saying they knew.
I don't know whether they knew, but it is mandatory disclosure, and it's the officer in charge of the investigation, I think.
Go ahead. Argument.
So, again, there's a recorded statement with a police officer. Neither side has, under People P. Jackson, 292, 583, as well as related case law. And
that there's an interview with this individual, correct?
That's correct, Your Honor. There is not an indication in the report that that review or that interview was ever recorded.
Well, if I may, one of the indicators that sort of flagged my attention is why did they go to his house but have him go to their patrol car to do the interview?
Then why didn't any attorney prior to you ask the people for that information? Why at this last minute do you come forth trying to indicate that there's some violation and some penalty that should be attributed to the people? Where were your attorneys before now?
I can't answer that at this time, but what I can say is I did reach out to the people yesterday. I sent 2 emails about this case. I didn't get any response. So even if not for any other reason other than at least, and again, yesterday was a holiday, like none of us were required to work. So I'm not faulting Mr. Cook. I'm not faulting the people for that. But I think that it is at this point a due process issue, and it's an issue that
a due process issue created by whom? If you're going to claim that your client's due process rights are violated and that it happened here, you better bring it, Ms. Yagi. Because the responsibility to also uphold your client's due process rights rests with your office. And you guys have had this case for quite a while now. So I'd be careful about where you want to point fingers on that line. I'll let you continue if you want to continue right now, but you better be careful.
If I may just have a minute, Your Honor.
You can. Take as much time as you like. In fact, court's going to stand in recess.
Well, we can fast forward.
You may be seated.
We can fast forward because we're catching up. This happened this morning, a couple hours ago, right around lunch. Looks like everyone's still huddling around the podium, the lectern. Let's wait for the judge to come back out. Still waiting for the judge to come back out. Still waiting for the judge to come back in. What in the world? Are you guys seeing this?
I don't like podiums, Your Honor.
He left the bench. That was an hour and a half ago. Oh, he's back. He's back. He's back. Holy smokes. He left the bench for a long
I left the
time.
file. Next, Lily left.
What did he say? What's his excuse? Everyone's just sitting here waiting for the judge.
All right. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Day 17.
You may be seated. Can you have Ann? I left the file. Next, Lily left.
I can go get it.
No, he's I was just going to blame somebody besides me.
What did he just take an hour break for? In the middle of a hearing.
Court does call the case People versus Corey Folk.
Good afternoon again, Your Honor. Brandon Book for the people.
Public defender with before you vote, standing to my right. Could you say your name to the court for Folk?
All right. Record should reflect we've had a couple of in-chambers conferences regarding this that have gone throughout the day and trying to resolve some issues. I think well, I'll let you say what you're going to say. Go ahead, Mr. Clark.
Thank you, Your Honor. I previously indicated the people were able and ready to proceed today. I would note that as of now, that is no longer true as one of the people's necessary witness. A witness that I believe has been the subject of much discussion for this case has left the courthouse and is no longer responding to attempts to communicate with him or to reach out and find him. We are unaware of his whereabouts at this time. As such, the people are not ready to proceed at this time with that witness. And I believe previously defense counsel referenced a desire to adjourn so that way she could have more time to review the case as well as for the parties to usually go over some of found discovery that exists that both parties like to review as it relates to that potential witness's testimony. I did also want to make a brief record related to that additional discovery, as there was a claim that the people, I believe, the term used was a discovery violation, or that somehow the people were withholding this discovery. I want to make it clear that I did not know this existed until today when Ms. Yagi dutifully was looking through the available discovery and inquired about whether this particular item existed. I asked the officer in charge whether that item does exist, and he indicated that it did, but he did not believe he ever sent it to our office. Nevertheless, I asked him how soon that would be available, and he indicated that it should be able to be copied to a disk and provided to both the people and defense by the end of the week. And I will make sure that that gets done as soon as time allows. I would also just note, again, this is not important to the court's decision today or the people's request, but just making a record. In the report, there's the original report as well as numerous supplemental reports. And of those reports, there's indications of body cam being on some of those reports, but not on the report that would have the interview of this witness. So there was no mark on there. Body camera was on a recording. And so I did not think that there was any until I discovered that it was today. As it stands, I would be joining at this point with defense counsel's request to adjourn the preliminary examination for today. I believe that the date we had discussed was June 15th at 9 in the morning. I have confirmed that that date works with 3 out of the witnesses. 1 witness is unavailable, but I am confident being able to proceed without that witness. And I was not able to confirm that date with the missing witness for obvious reasons. I believe that's where we stand, and that's the people's request.
One other thing, I'll just indicate that there might be a request for a material witness warrant should the people feel that's necessary given the individual having left and them being under subpoena. Ms. Yagi.
Yes, Your Honor. That is correct. And I will certainly follow up regarding the outstanding discovery.
And let me, just for the court's purposes, say this. I was dealing with this all day from different perspectives and different angles and seeing what we could accomplish today and could we go forth today.
Get an apology.
I watch and preside over week after week, where I watch two of what I believe the state's most efficient offices in terms of what they have to do in our criminal justice system, that being the Washington County Prosecutor's Office and the Public Defender's Office, and that to watch them work tirelessly to try to make sure that all of the evidence, everything is provided, when certainly there could have been a point, not saying that they would, where the people might say, well, we don't have to worry about that piece of evidence. They voluntarily disclose that there's this other thing out there that may not even belong to a police agency, it might belong to a third party. Let defense counsel know, and they endeavor to get all of that. Now, I say that because, and I didn't hear everything on it, but I assure you, Mr. Cook, that when the representation was made that there may have been some intentional non-disclosure, I think by my reaction, I think you should have understood. I don't buy it. I don't believe that's what happened in this case at all. I don't believe that you knew, as you've indicated. I think that it's one of those things that's there, and quite frankly, in reading the report, is going to be equally as plausible to the defense, who could have then made the request, as it would have been to you. And so that's the way that this court's going to handle it. And as I said, and I'll be frank with you, Ms. Yagi, if you're going to come at somebody, you better bring it, because I don't tolerate anything in between. Preliminary examination in this matter is adjourned June 15, 2026, 9 a.m. before me.
Wow.
Bond will continue. Thank you.
So that's how that one ends. Let's go back to Kansas, shall we?
What happened to?
Let's jump back to Kansas.
And Missy, when's her next court date?
July 31st at 9 a.m.
If the county attorney doesn't dismiss that ticket before July 31st at 9 a.m., you do need to be back here, Miss McElroy.
Okay.
McElroy?
But go down to the county attorney's office, talk to them about it, show them your proof, and then don't forget to go around to the county attorney or the sheriff's office before you leave town or leave the courthouse.
Okay.
You go pop
Thank
some
you.
tags.
Thank you. You may go.
Thank you.
You're welcome. Anyone else in the courthouse?
Yeah, we got
one more, ma'am.
Oh, thank you.
Two more. I'm sorry.
Two more. All right. What's your name, please?
Renee Wade.
You're Renee Wade. Miss Wade, I missed you at an earlier hearing today. You'll need to call your attorney on that case, Blake Cooper. You know how to get a hold of Blake Cooper?
No, I can call mental health. I call mental health.
All right, we'll do that. All right, at this time, you're charged with count 1 burglary of a non-dwelling. The state is alleging that on April 21st
business or construction site
of 2026, you entered into a home. Strike that. You entered into a building that was not being used as a home, and that you did so without authority to enter into, or you remained within the structure, which is not a dwelling. And it's believed you entered into with the intent to commit a theft. Specifically, they're saying you entered a carport at 303 South Greenwood in Severy, Kansas. Now, as a level 7 non-person felony, if you were to be convicted of this, Miss Wade, you could be looking at penalties, including a prison sentence from 11 to 34 months and a fine up to $100,000. In count 2, you're charged with taking control over property with the intent to permanently deprive the owners, Kathleen and John Knoll, of the possession, use, or benefit of the property, to wit, assorted stored items. Approximate value under $1,500. As an A non-person misdemeanor, if you were to be convicted, your sentence could be up to 12 months in the county jail, and you could be ordered to pay a fine up to $2,500, as well as restitution for anything taken and not recovered. Miss Wade, are you able to hire an attorney?
No,
All right. Are you working?
no, I'm not.
All right. I think I know your circumstances well enough to know that you do qualify for court appointed, but if you can fill out an application there that the deputy would give you, that'd be great. But I'm contemplating appointing an attorney. Check back, Missy, when do you want her to check back for an attorney, see if she qualifies?
Friday?
Okay, check back with Missy on Friday at the courthouse and see if she's able to find an attorney that would be just the right fit for your case to help you. Okay? All right, and Missy, when does she need to come back to court with that attorney?
July 17th at 1:30.
July 17th at 1:30, and I want you back at the courthouse, not by Zoom. Is your husband by chance with you?
Yes, he is.
Mr. Wade, are you there?
Yes, ma'am.
Can you help her get back to court July 17th at 1:30?
Yes, ma'am.
And to call back Missy Friday and find out who the attorney is?
Okay. We'll
And
do
then
that.
if you want to stop by the county attorney's office, they can tell you about the hearing she missed today, if you're not familiar with it, and how to get a hold of her attorney. What happened?
Okay.
All right, thank you. Anything further? Has she posted a bond?
Yeah, I bonded her out when she got arrested.
Looks like she did have a bond, and I will continue that $5,000 surety bond that she posted 4/21 of 26. So just make sure she gets back here, Mr. Wade, please.
Okay.
All right, thank you. You may
Thank
go.
you. Got another one in here, Your Honor.
Okay.
Okay. I better get to
Hello, sir. What is your name, please?
Gary Holt.
Gary Holt.
this number I will help you with after you're done with it. Sure. Yep.
Well, she's looking up this case. Just want to let you know my son's flying out this afternoon, or my wife's leaving to take my son to the airport, so I'm going to be wrapping things up here in just a little bit.
We're on the
Say leave
record in
an hour.
GW 2023 CR 3000027, State of Kansas versus Gary Ray Holt. County Attorney Jill Gillette for the state. Mr. Holt appears in person and
Ernesto
pro
Big Young.
se, although he does have William McClendon of record. However, Mr. McClendon's duties to the court would have ended when you pled and were sentenced April 23rd of 2024. You were placed on a 12-month supervised probation with court services and certain conditions. Now there is a motion to revoke your probation. Are you going to hire an attorney, apply for court appointed, or represent yourself, Mr. Holt?
Apply for a court appointed.
Do you work at this time?
I'm self-employed. I build fence.
You build fence?
Yeah.
How much per month on average do you make doing that?
Right now, anywhere from $900 to $1,500, depending on the fence.
All right. And
Is that per
are
month
you married or
per week?
single?
I am single, but I am taking care of my disabled mother.
Okay. And do you have any minor children that you legally support?
Uh, I'm supporting my son, but my mom has legal custody of him.
How old's your boy?
12.
Well, okay.
Mom has custody, but you're caring for
And do you
mom?
pay rent or a mortgage to your mom or anyone?
I'm paying her house payment, which is $435 a month.
Do you pay the utilities?
I pay half of them.
How much is that?
Average couple hundred, I think.
Okay. Any other expenses?
I'm paying for an interlock, and I'm been making fine payments, and I'm saving up for treatment.
Okay. All right. Well, I'm going to find that you qualify for court-appointed attorney, and Missy will check and see if Mr. McClendon can and will take your case back. Missy, when's the next court date?
Let's set this for show cause June 23rd at 3:30.
All right.
said
You must be
3:30?
back 3:30, and you said June 23rd?
Yes.
All right. You must be back here June 23rd at 3:30 at the courthouse. Not
Yes,
by
ma'am.
Zoom, but at the courthouse. And go by Mr. McClendon's office today and see if he's in and let him know how to get a hold of you and all that information.
Yes, ma'am.
You know where his office is?
No, ma'am, but I was
You
going to
know what-
ask around.
You know where McElvain's office used to be?
Yes, right across the street.
My understanding is he purchased that and is practicing there.
Okay, thank you.
You're welcome. All right, you may go at this time, sir. I'll continue. Let me check your bond.
Judge, do you want him to fill out that paperwork also?
Nah, he's good.
Well, why don't you have him do that as best he can? And I'll continue the $5,000 bond you posted. Looks like April 30th of this year with Florio. But you have to go check with your attorney and then be back here ready to go at the courthouse.
All right.
All right, you may go at this time, Mr.
All right.
Holt.
I'm going to go.
Thank
Thanks,
you.
Judge.
You're welcome.
All right. I told him my son's flying out. My wife's taking him to the airport. He's actually flying at just a terrible, terrible time in the middle of the night. Well, terrible for us. He arrives great time on the other side, but he's my second oldest. Found somebody he's interested in. We're going to go hang out with their family a little bit, get to know them a little. So he'll be back in a week or 2 weeks or so. But and then he'll fly back out to school after that. So, yeah, he's been with us for a couple weeks. We've loved it. It's awesome. But now he's flying back out, and Mrs. R.A. is going to facilitate that by getting him to the airport on time via a hotel, so you don't have to drive at 1 o'clock in the morning for 5 hours. So that's going to happen tonight. So I'm going to go wrap things up a little bit with him and make sure they get out the door and everything happily. And don't forget anything. And most importantly, don't take the car keys for the other car, which I'm going to need tomorrow. That's the one I'm interested in. So anyway, nothing to announce as far as announcements there, but they're really happy together. They like each other. So that's it. It has been a fun day. I mean, we haven't had a day with this much excitement and court hopping in quite a while. So I'm glad you guys get to jump in with us and watch this through this. It's 4 o'clock now. It's time to quit, I think, especially since we had a holiday before. The like-to-looker ratio was way off. That's all right. It's all right. We'll get it fixed. We are also still striving for acceptance in South Carolina. We're hoping that Jamie down there is able to call us back and give us the link for the pool feed, which we've requested, and hope it works. South Carolina is one of those states that allows you to request it as much as 30 minutes before the hearing and still be approved. So I'm hoping that works. Somebody said lawyer is doing something. We should portal to him. I'd be happy to do that. I don't know what it is, but do tell me. That would be just great. Let me see if we can find Peter's post. Let's see. Is it The Real Lawyer Reacts to Netflix's number 1? Is that the one? The Crash. All right. We'll do it. We'll portal over to Peter Tragos. Say hi when you get there. Be kind to everybody. Tonight when you go home, please hug the people you love. Smile. Someone make their day just a little bit better. And please stay safe till we go live again tomorrow morning, hopefully with news of a court case we can follow. You guys, we'll see you tomorrow.